Today, I'm going to talk about one of the biggest changes to come to our industry, and that is the change in our agency law of having the buyer agreement in place and signed. As of 2024, we are now required to have a buyer service agreement in place. So today I'm going to talk about not only our specific company form to John L. Scott, but the statewide Form 41 for this buyer agreement. As of January 1st, 2024, there is no longer an implied relationship between the buyer and the agent. All agency relationships are established by written agreement. If you do not have a written agreement, then you have no agency relationship with the consumer. According to agency law, we owe very different duties to those we represent and those we do not. So how do we start talking about this with our buyers now that we know it's Washington state law that we cannot provide real estate services until this agreement is signed? Number one, you're going to have that compensation conversation with both your buyer and your selling clients. You're going to have to explain how the compensation is paid to the listing firm and the buyer broker firm. You're going to have to explain how the compensation is negotiable, as it is set forth in both this exclusive sale and listing agreement as well as the buyer service agreement. Then you're going to want to explain how a buyer may ask the seller to pay the difference in the compensation as part of their offer, if the seller is offering less than the buyer has agreed to pay the broker. And then finally, you're going to have to explain how the compensation offered by the seller is public, and it's published on websites and disclosed on the first page of the purchase and sale agreement. The whole idea here is to have transparency with how we get paid. So think about your agency duties. The agency duties that you have once you sign this agreement are going to be in place until it ends. So when does it end? Well, it ends in one of four ways. One, it could be the completion of the performance by the broker. So this means you write up a sale and you close it. Now your agency relationship with that particular buyer has ended. Number two, it could be the expiration of that agreement. So say you gave that buyer a 60-day time to work with you, and at the end of the 60 days, you can both choose to part ways or you can continue to reinstate the agreement. It could be terminated, but it has to be mutually terminated. Or you could terminate the relationship from either one, but that doesn't necessarily take away the obligation to pay the broker. So as we look at this, the first form I'm going to pull up is the John L. Scott Form 41. When you're doing this, making sure it's the most current one. The one that we have on file is now dated as of 1/2024. So filling this out is going to be just as we've done before. The buyer agreement is made between the firm and the buyer or buyers. If you're working with more than one buyer, you're going to want to put both of their names in here. The office that you're going to put down as the firm is the office you are associated with. And the effective date is today's date, whenever that may be. Now, if you're looking in certain geographical areas, the best thing to do is to be specific or be prepared to show the entire state of Washington. For instance, if you want to show a certain neighborhood or a really specific area, you can list the house, you can list the city or the county, the entire state. What we want to avoid doing is putting an ambiguous statement in there that only agents are going to be aware of. We don't want to put the area numbers that we are accustomed to. We want to make sure that this is very clear to this buyer what areas you are planning on serving them with. Now, in handing this over, the very, very first thing we need to make sure we're also doing is delivering the agency pamphlet. And that's going to show them what your duties as the broker are to them. That pamphlet has been renamed to the Real Estate Brokerage in Washington pamphlet and has been really kind of streamlined into more layman's terms that are much easier to understand so that client knows exactly what your duties are to them. Next, you're going to go ahead and write your name. the agent, because you are the person who is going to be providing these real estate brokerage services. Now, in order to show this buyer what you're going to be doing for them, our company specific form has laid out this chart, which gives you a great talking point when it comes to how you're going to help them. It also helps create the value that we bring to the table as buyer's agents. So go ahead and use this circle and explain to them the home buying process and how it works with you involved. Next, you're going to discuss the term of your agreement. So it defaults to 60 days if left blank. If a buyer wants to go beyond the 60 days, you can feel free to decide that right off the bat, or just leave it as it is. Sometimes you'll have buyers that you may start working with for the first time and not know if the two of you are a good fit. So this negotiable time frame is really great for that kind of situation. Next, you're going to explain in detail what the agency relationship means, and the fact that when they sign this, they are creating that agency relationship. In the pamphlet, it will not only show the duties you owe to the buyer as their agent or the seller as their agent, but also explain what it means to be exclusively bound or non-exclusively. Make sure you go over this and what it means to those buyers. Make sure they understand that an exclusive relationship means that it really doesn't matter how they came about the property. If they choose to write an offer on it, an exclusive relationship means they are going to use you as their agent and you are entitled to the compensation. Non-exclusive relationships mean that you need to be the one to go ahead and write up the offer because it is possible they could be working with another agent. In the same idea, we also want to let our buyers know that if we have a signed exclusive agreement in a specific area, they are not allowed to sign another exclusive agreement in the same area with any other agent while this is still in place. So what are you going to pick, exclusive or non? Well, let's talk about the exclusive duties and talk about duties that we owe to buyer and seller and how this might interfere if we are going to move into our next discussion, which is going to be the dual agency. So as a broker, you owe to the buyer or seller the duty of loyalty. You may not take any adverse action against them. You may not do anything that's detrimental to their interest in the transaction. You're going to disclose any conflict of interests. You're going to advise them to seek legal advice when it's beyond your scope of expertise, or you're going to lead them to somebody who is an expert in the area where you are not. You're going to disclose you're not going to disclose any confidential information about them, and you're going to continuously make a good effort to find them the property they desire. Especially with number 5, you want to make sure if you are committing to the entire state of Washington, that you are truly committing to finding them property and you are willing to go to those places. Now, duties to all parties. So if you are going to be talking with buyers or sellers, we all need to make sure that we're exercising good skill and care. We're dealing honestly. We're going to be presenting timely offers, working in a manner that is ethical. Material defects need to be known no matter who we represent. And we are always going to be providing the agency law pamphlet. In our purchase and sale agreement, we also want to make sure that we're disclosing which broker represents which party. When discussing those duties with your buyer, the question will come up as to what happens if you find a home for that buyer that you happen to be the listing agent for. This is the time where you need to explain to them the difference of being an exclusive agent versus a limited dual agent. What a limited dual agent is going to have to do is not necessarily the same as an exclusive agent for that client, but rather you're going to have to act in more of a mediator capacity. In a dual agency situation, you will not be able to advocate for one party over the other because you cannot do anything detrimental to one party if you have the agency agreement with them. This is something that as of 2024 now requires the consent in order for you to take this role. So in paragraph 5, what we're going to do is have that discussion with our client and ask them that in the event they find a home that you are also the listing agent for, if they do or do not consent to you being a broker on both sides. If they don't, feel free to refer them to someone else so they can have proper representation. In this, though, there is also the caveat that the firm will potentially be a dual agent because any broker overseeing the entire office is putting themselves in a place that could be talking to somebody from both sides of the transaction. Limited dual agent duties, like I said, are very different. You may not advocate for a term more favorable to one principal over another. And when you're acting as a dual agent, you may take no adverse reaction or no adverse action or anything that is detrimental to either person. You still have to disclose to both people that you are the dual agent. You will need to advise all the people you represent to seek legal advice or expert advice in areas that are beyond your scope. You still cannot disclose any confidential information about either person. And you need to continuously make good effort to find property for a buyer and buyers for a seller. Now, part of this agreement is discussing our compensation and the transparency of how we get paid. So in our form, paragraph 6 decides the compensation that is going to be paid. This is a conversation that the agent will have with their buyer. They will put the amount of compensation that they are going to be asking for in 6A, paragraph I. And in the event that that buyer broker is allowed to be a dual agent, they can fill in paragraph 6A II. If there is no consent to dual agency, then there's no reason to fill out that paragraph. So if it makes your buyer feel better, feel free to cross off that paragraph. And this is definitely a discussion that you're going to have on a case-by-case basis with each buyer you talk to. Now, the important part about this is what you decide on for your compensation is the amount that you are allowed to be paid. You can't write a number in here and then negotiate beyond that if you're only obligating your buyer to pay you a certain amount. So be careful what you write in these paragraphs because they're going to limit your ability to negotiate on a purchase and sale agreement beyond the numbers that you put in here. Now, after this agreement expires, there is a tail provision. And just like a listing agreement, if a property is brought to the attention of that buyer and then your agreement ends, there is a time frame after that where that buyer may be required to pay you the compensation for purchasing a home you've shown them. In an exclusive relationship, this means it could have come to their attention either online or with any other marketing efforts. In a non-exclusive relationship, though, this means it needs to be written up by the person on that buyer's behalf. Now, if you have a conversation with your buyer and they are not comfortable coming out of pocket paying, if any properties are not offering any payment, you can negotiate with that buyer if they want to see them or not. Remembering that the compensation is negotiable and it's negotiable by every part. So when a seller offers an amount of compensation publicly, the buyer does have choices on how they can respond based on the number that they've agreed to pay their own broker. We need to remember technically, a buyer is responsible for their buyer broker's payment, and the seller is responsible for the listing broker's payment. Now, that seller can choose to offer a compensation to the buyer broker who brings them a buyer, and that will be published on the Northwest MLS. Because it's published on the Northwest MLS, a buyer can see ahead of time if they're going to be offering a compensation that is equal or close to the amount that their own agent is requesting. So in the event that perhaps a seller is offering more than this agreement has in place, there are a few choices on how we can choose to move forward from that. We can choose to have the excess paid to the firm, which would be the agent. The excess could be credited to the buyer, or the excess could be credited to the seller. There is an other box too that I'm sure could be a whole arrangement of other options. But if the compensation being offered is more, then the buyer is not obligated to do anything further. The buyer is accepting the fact that there is a minimum compensation being offered, which is what they were willing to put in, and you can go ahead and make the offer on the sale. Now, should the offer come in and the compensation offered be less, then there are a few other choices as well. If the offer is less, the buyer can choose to ask the seller to pay the difference in the purchase and sale agreement, and we can negotiate that. We can ask the balance to be paid by the buyer, or we can choose something other than what's in here. Remember, whatever negotiation happens with that compensation needs to match the amount that you've obligated your buyer to pay. Now, the buyer can also just say, hey, with nothing offered, I really don't want to see it because I don't want to come out of pocket with money to pay my broker. So you can also label out in detail what your buyer does or does not want to see based on any compensation that might be offered. Now, keep in mind, it is negotiable as well. So a buyer may have a little bit of fear of seeing something that doesn't have anything offered, but if it's possible to negotiate, then you may want to at least offer the idea that you could still send them the listings. Now, certain financing is not going to allow a buyer to come to the table to pay their agent with money. So if you are dealing with a VA buyer, it is quite likely that the seller at the end of the day will somehow have to pay that compensation. Nonetheless, it still has to be negotiated in this manner. It really doesn't change the process of how we do things. It just changes what's allowed by the lender. And then our last part of this form are just the normal kind of clauses that we've put in what forms were in place before. So we are always going to recommend doing inspections. We're not going to be able to assist a buyer on a distressed home, which we don't actually have very many of those here, and distressed homes have their own definition. We are going to be acting fairly, and we are going to comply with all the fair housing laws. We are not going to be discriminating against any of the protected classes listed. The agreement that's in place is the agreement, and everything is in writing. So it's going to be held up in the standard of this here. And then, of course, the attorney provision saying that if anything goes to litigation, the prevailing party will be the one awarded the attorney fees. Now, that was the specific form to our office. The statewide Form 41 has the same things in it, so I'm going to breeze through it a little bit quickly, but still bring it up because this is going to be the one that most people outside of the John L. Scott family are going to be familiar with. Form 41 still has a place to put our office, our buyer or buyers, and then our area. Again, as a reminder, make sure that you are not putting area numbers, but rather an address, a city, a county. Make sure your agreement is stated for how long, because this one also does default to the 60 days. And the pamphlet must be given. So number one is the pamphlet. Number two is also going to be your name. And in the same way that you presented it before, it's going to be the choice of the exclusive or non-exclusive agency. With the limited dual agency, there's still the consent here. It has to be signed to be consented. If there's no initials, there's no consent. Team structures should be careful because when you're obligating or you're obtaining consent for dual agency, you need to be aware of how your team works and who may or may not be a dual agent. Any managing broker who oversees the brokers are automatically disclosed as a potential dual agent. And sellers don't really get a choice as far as a supervising broker, designated broker, because we may be able to sell within the firm. But the idea behind this is really just the transparency of who we represent. When compensation is going in, we want to go ahead and discuss with our buyers how this is going to work. We're going to put in the amount that we would like. And as a dual agent, this number is going to be the total amount. If there is additional compensation that we want for taking on both sides. Remember, if the buyer does not consent to dual agency, doesn't matter what you put in this blank, because there is nothing that can be done if they have not consented to it. This, just like the company form, is going to have the options on how you can negotiate the compensation if it's either equal, greater, or less than you've decided in this agreement. If it's equal, there's nothing to be done. If it's greater than that, then the options below are the same as the other form. We can pay it to the firm, pay it to the buyer, or pay it to the seller. And if it's less, what is that buyer going to be prepared to do? Is the buyer going to be prepared to come to the table with the remaining pieces? Are they going to ask you to negotiate that as part of their purchase and sale agreement of this property? Same terms as far as we want to talk about exclusive agency, non-exclusive agency, but this compensation after expiration is the tail provision of this form. So like the other form, it defaults to 60 days. And exclusive agency is just as a tail provision is for a listing agreement. Non-exclusive, again, has to be written by the agent on behalf of the buyer. We can still filter and we can still discuss with our buyers about certain types of financing that may or may not allow a buyer to come to the table with additional money for their broker. Please note that VA financing does not allow a buyer to come to the table with compensation to be paid. And then, just as the other form, the same clauses exist in the last page to cover fair housing and the attorney provision clause. I appreciate you listening. If you have any questions about this buyer agreement, please feel free to reach out and have a great day.